Hello friends, today we are talking about the general exceptions under Indian Penal Code. Section 76 to Section 106 of Indian Penal Code says about different category of general exceptions. We can know them as general defenses also. Particularly 8 category of general exceptions are provided under Indian Penal Code. Out of these 8 exceptions, today we are discussing about some of the exceptions in which section 76 to section 80 says about 3 types of exceptions, in which the first exception is known as mistake of fact, second one is known as judicial act, and third one is known as accident. Today we are talking about the first exception that is provided under section 76 and section 79 of Indian Penal Code, that is known as mistake of fact. Before proceeding towards mistake of fact, let us try to analyze the scheme of sections regarding these general defenses. Section 76 and section 79 says about the first defense, that is known as mistake of fact, whereas section 77 and section 78 says about the second defense, that is known as judicial act, and section 80 says about the third defense, that is known as accident. So let us try to analyze the first defense under Indian Penal Code, that is known as mistake of fact. So what is mistake of fact? Mistake of fact is a mistake done regarding understanding a particular fact. Here is one Latin maxim which tries to explain this defense in a very exhaustive manner. It says that ignorantia facit excusat, ignorantia juris non excusat. That means ignorance of fact can be excused, but ignorance of law does not excuse. So the maxim says that if a person is not in a condition to understand the fact, and if he does any mistake while considering a fact, such mistake can be ignored by the law, such mistake can be excused by the law. However, if any person makes any mistake while considering any law, if he says that he is not aware about the law, then such mistake will not be considered by the law, and such person will not get any defense or excuse for ignorance of law. Section 76 and section 79, both sections under IPC says about this mistake of fact. The first proviso in this relation, that is section 76, it says that act done by a person bound or by mistake of fact believing himself to be bound by law. Section 76 says that nothing is an offense which is done by a person who is or by reason of mistake of fact and not by reason of mistake of law in good faith believes himself to be bound by law to do it. As per section 76, it says that if any person does anything, that is, which is done by a person who is by reason of mistake of fact and not by reason of mistake of law, if he in good faith believes himself to be bound by law to do it, such person can be exempted from criminal liability. So anyone who does any act under any mistake of fact, and while doing the act, if he is acting in good faith, and if the person is bound by law, then the person can take the benefit of section 76. Section 76 is applicable only to the persons who are said to be bound by law. The term bound by law means the person is under legal obligation to perform the act. So whenever a person he is under legal obligation, if he is bound by a duty to perform a particular act, and while performing the act, if he does any mistake, such mistake can be exempted by law. So one illustration is already given here. It says that A, an officer of court of justice, being ordered by that court to arrest Y, and after due inquiry, believing Z to be Y, arrest Z. A has committed no offense. If we see the example strictly says that A is the officer of court of justice. That means he is under legal obligation to perform an act. While doing the act, the court has directed him to arrest Y. But as A is a person who is not aware who Y is, and so he has made due inquiry that who Y is. But in this case, as A has made due inquiry, that means he has acted in good faith. He has taken all proper cares to identify Y. But believing Z to be Y, he arrested Z. So in this case, A has committed mistake. Instead of arresting Y, he arrested Z. As if we see the ingredients of section 76, it says that if a person is bound by law, if he is acting in good faith, and if he does any mistake with regard to the fact, he can be exempted from criminal liability. So in this case also, A being the officer of court means he is under duty to perform the act. He has taken due inquiry with regard to the Y, so he has acted in good faith, and he has done mistake. Instead of arresting Y, he arrested Z. That means he has made mistake. So such mistake can be considered under the category of mistake of fact, and A can be exempted from criminal liability. Second important section which provides about the exception, that is under section 79. It says that act done by a person justified by or by mistake of fact believing himself to be justified by the law. The only difference between section 76 and section 79, that is the term bound by law and justified by the law. Section 76 use the term bound by law, that means the person is under legal obligation to perform the act, whereas under section 79 it used the term justified by the law, that means all other persons other than the persons bound by law can take the benefit under section 79. The act is justified by the law in the sense the act must be of such a nature that which can be exempted by the law after giving sufficient grounds. So section 79 says that if a person does any act, and if the act is of such a nature that which can be converted to the mistake of fact, not under the mistake of law, the person, if he acted in good faith, believing himself to be justified by the law, then his act can be exempted under section 79. So section 79 says that nothing is an offense which is done by a person who is, or by reason of mistake of fact and not by reason of mistake of law, in good faith believes himself to be justified by the law to do it. So what are the important requirements of section 79? The first thing, the person must have done certain act. Secondly, he must have done mistake of fact. Third, he must act in good faith. And the fourth one, his act must be of such a nature that which can be justified by law. If he fulfill all these requirements, any person other than the persons provided under section 76, all other persons can take the defense of mistake of fact under section 79. So section 79 is also important section with regard to the mistake of fact. Thank you very much.